The school board alleges that the opt-out system became unworkable. Is that a factor we should take into account in deciding whether it could be required?
Certainly, there could be situations where it could be unworkable. The board never raised that until after this litigation commenced. When they announced the withdrawal, they said it was because every student needed to read the inclusivity books. When they produced documents in response to an open records request, there was no mention of it not being workable. When parents met with the superintendents, this is in the Hisham Garti declaration at JA 44. The reason given there was inclusivity. There was no mention of administrability until the litigation's been filed. And even then, all the board was able to come up with was an argument that in one instance, in one school, there were dozens of students who opted out, where if the average school size in Montgomery County is 700 students across at least a dozen classrooms, you're talking maybe one student per classroom. That hardly compares with the 1 in 8 students who are opted out for individual education programs. 15% of students in Montgomery County who are taking English for speakers of a second language. The board's own opt-outs that are required from the same instruction required by state law to be opted out when the same books are read in health class.
Counsel,